Things are going to start happening to me now.
I think Tyler is amazing.
And I'm a fan of this show. I've watched several episodes.
Thank you, Tyler. Thank you, Tyler. You stink, Tyler.
Never promise crazy a baby.
Oh, I like that. That's a cool idea.
Are either of you homosexuals?
I go both ways. What do you think?
You mean like flaming or?
No, we're not homosexual, but we are willing to learn.
But I do wonder, for others, in other cases, whether libertarianism today is just an excuse for many on the right to act selfishly.
Look at me. And then some fat asses in Washington started having opinions. The Olympic Committee started having opinions. You bitch, I know you! You started writing your opinions.
And it just makes me wonder, you're dead, bitch. You know, why are you doing this to this poor guy?
I don't care. I'm a libertarian. What I'm getting is,
Did you vote for Joe Jorgensen or Trump?
Who?
Joe Jorgensen. That was the perfect answer. Thank you.
LPR on a Friday afternoon, Friday night. Depends on where you are. Welcome, everybody. This is Tyler Yonke, your weekly dose of, I don't know what it is. I will say, and this is probably just what I just did there didn't help, which is, and by the way, hello, everyone. One person is like your show, seems to be cool, but you need to be on your ADHD meds. Bad. I'm like, look, I'm 53. I work hard all week, and then I come in here and I don't have anything planned, and I try to do this show. And when I do, perhaps it seems a little bit unorganized. I've spent my whole week, and then Fridays are ridiculous. They are people come out of the woodwork all week. I'm banging on, hey, I need this, da da da. And all of a sudden Friday is when they think that they need to come in and start pestering me. Now, my problem is Friday, I'm trying to be done at noon. I'm trying to go home, hang out with my family, see what's going on, da 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 da. Imagine being 53. And so I get a little distracted, and then I try to take care of the chat. Now, let me just throw this out there. Maybe you think I have ADHD or whatnot. I was able to get an engineering degree. Okay, so I'm not a dummy, but I was able to study hard. I went to grad school, quit grad school, and yikes. And did professional cycling rode for a pro team for a while. I've done multiple licenses for stock trading. We've talked about that a bit. I went to law school. I'm doing fine. I run my own business. I got a lot going on. Okay, maybe you're correct. I don't know what the symptoms or whatever of ADHD are, other than, look, I'm doing this. I get sidetracked. I try to bring it all in together. I'm not reading a script, people. So here you are. Here we are. And what is the topic of here? See, this is what happens. Then I get so many things I want to talk about. I heard, I wasn't even paying attention to the news today. I heard that RFK Jr. Dropped out of the race and endorsed Trump. Mario, I think is his name, Narfal or something like that on Twitter. He followed me. They keep saying, hey, come into these spaces. And I'm like, this would probably be really good for my online presence or whatever, right? So I'm like, sure, I'll try to do it. And they'll allow me to join. They put me on as a speaker. But then this week it was like, hey, let's talk about the DNC convention. And I'm just like, and then the people that are in there and they're arguing and it's so stupid. And I'm just, I just tuned out. I'm like, no, they had me added in multiple days and I started, and then I just said, screw it. It's not worth it. I have a job. I have other things, going on here. Self-medicating with success. I guess so. I guess so. I will say this on the ADHD, and once again, maybe I should look into this, but I'm not going to take any meds at this point, right? I've been successful. I think I do fine. And perhaps I've always noticed, though, when I studied, that I study with music, or even at work. I always have the TV going. I'm listening to podcasts. I'm doing something. And when something really I need to focus on, I will stop it because sometimes it's like, oh, I'm missing out on what the podcast is saying. But to me, it's almost like I have this, I need almost a white noise. I have something going on that takes part of my brain and just, it associates with that. and it's picked up on that, and then I can just focus. So maybe this has been my way of dealing with this all my life, and I've been fine with it. I've been doing well. So, okay. So what's on tap today? I thought we'd go over some Nick Rekieta stuff and also Frank's motion and Leo Frank. Okay. Leo Frank is coming back into the fore a little bit, and I thought it would be interesting. Should we play around with these cameras? I've got some new, look at this side camera. We got the front camera. Okay. And I thought Leo Frank is coming back. If you don't know much about him, I do have some work I'm going to be doing on this Leo Frank case. It's a thing from 1913. It's a gentleman that diddled a girl and killed her, and then there was a whole case about it, and the ADL kind of was formed out of there, but not really. But and there's a lot of myths. The ADL just had a whole thing saying, "May his memory be a blessing," which spurred up a lot of controversy online. I did a full 4-part series, 3 of it with Pete Quinones. One did the initial one myself, and then he came and we did that. There's some myths, and I think there's like top conspiracies associated with the Leo Frank case. I'm rereading this book, The Secret Relationship Between Blacks and Jews, the Leo Frank case, and it's fantastic. And there's so much out there that's wrong. And so what basically happens, this guy does this. There's a whole trial about it in Georgia in 1913, and there's a lot of significant things that came out of there. So I don't know if I'll talk about it right now. I just thought I would throw that out there. There are some things I'm breaking down, and we'll go through as well. You really sound hyper at 1.25 while I catch up. That's how I listen to it. And by the way, thanks, Dwayne. Welcome everybody in here. We've got JC and Alan. Love to see all you guys in here. Hannah, good to see you too. I do talk fast, and when I get going on rolling, I do talk really fast, and then I need to like back up to grab some things in my mind to pull them back up. So you're just gonna have to deal with it. I mean, I don't know what to tell you other than when I do go well, I do go well. Man, there's so much. I wish sometimes that I could be like these, Sean and some of these other people, Nick. Get online here and just go for hours. I can't do it. It's 5:11 p.m. on the Pacific Coast, and I've got other things to do. I do love all this stuff, though. Okay, let's maybe get into it. I thought Nick Rekieta, he's got 2 cases going, right? There's the CPS case, and it's almost wrong to call it a case. And then there's this, it's a CPS issue, I want to maybe say. And then there is the criminal issue that's going on. Remember, he got busted in. There's a warrant, all this stuff. They come in, they arrest him for drugs, whatnot, and then CPS, because there's mandatory reporters, and they come in, and then CPS, or the chips they call it there, they have an issue. They took his kids, and we've walked through some of those transcripts. There was the ruling from the initial emergency hearing. Finish off that. We can do that. I just want to say, because I was on with Legal Mindset, and I appreciate a lot of people that have come over here for that from there when you met me. He being Legal Mindset, and I had this conversation. I think I'm somewhat careful because I'm going to play some clips here, Nick. I'm somewhat careful of trying to say what would happen. I do family law, and so I try to stay in my lane of family law. I'm not a constitutional attorney, but I'm very interested in the Constitution, and there's aspects of it that I think I'm good with. 14th Amendment, we can talk about that at some point. Due process, substantive due process, a little bit of those things as well. So yes, but that's not where I practice my law. So there's other people that do this, and I don't do criminal. So when there's some of these issues that come about, I give kind of my opinion of, it's called issue spotting. That's what we do in law school, where there's an issue, there's a case, whatever, you have fact pattern, and then you spot the issues that are in there for causes of action or liability or whatnot. That's kind of what we're doing with some of these cases and like the Nick stuff, especially with the criminal stuff. But so a lot of the predictions, I don't know, right? Now, things seemed out of sorts when, Viva Fry and Barnes are talking about like, this is, it's bullshit. It's not even, okay, I get it. And now Nick is making some motions here. And I did see a few, and we had Uncivil Law. He did kind of a breakdown of this dismissal, motion to dismiss, and he got worked up about it. And then Nick does watch all these streams, so he makes comments as well. But anyway, there's this Lisa lady. She did a bunch of these clips, and they are fantastic. And I thought we would just go through here. Let's start with Nick. Add him to the stage. We'll do 1.25. There's so many of these little things I want to. Oh, hey, let's remove this guy from the screen. We don't need him there. There's so many of these things Nick actually makes some good points on, and I want not just in here, but in some of the other things. But he also gaslights us completely. He'll make some comments about like, you don't know the facts. And I'm like, yeah, you're right. I don't know the facts. And maybe you get off on a technicality, but it doesn't mean you're not a douchebag. Okay. It doesn't mean you weren't still doing coke around the kids. And I get it. Maybe that's a technicality that gets you there. He did make a lot of references about he's a non-practicing attorney and all these other ones that are practicing. And yeah, I get it. We all make mistakes. There's this Professor Hasness. He wrote this column, I don't know, it's a few pages, the myth of the rule of law. Okay. And I've talked about it a few times. And the idea there is that when you go into law school, and this permeates out when you're an attorney as well, which is there's two sides. There is your one side and the other. And as family law, it's not like a prosecutor that is only prosecuting and only sees this one side. I am on both sides of the issues multiple times. One client, you're talking about, trying to defend yourself against some sort of spousal support or child issue. You're a non-custodial parent. Next time you're the custodial parent and you're arguing the exact same issues, but from the other side. So these happen all the time. And so you know these laws. And so you get used to arguing both sides of the case. And that's kind of what this idea is. And Nick does talk about somewhat of that in there, of making mistakes, and I get all that. But anyway, maybe we'll just play this. Let's go here. Let's see. Hopefully
that whole thing about, oh, you can't raise someone else's Fifth or Sixth Amendment rights, and the prosecution had to concede that we were right. They conceded it in court. So, I guess maybe someone in their weird rage forgot that the confrontation clause exists. That little thing called the Constitution.
Okay, and look, here's the deal. Civil law was talking about this, and he's like, wait, you can't, because there's this motion to dismiss, this Frank's motion, Delaware v. Frank's 1978 case. Yeah, everyone that does criminal law, you pretty much know it. I don't do criminal law and still knew about it. Doesn't matter, but what's his name? What's on civil law's name? Someone throw it in here. He was saying you can't assert someone else's rights. Well, Nick is right in this instance, talking about the confrontation clause, about not having to testify against yourself or being able to confront your the person, the witness. And with that, there's still processes and rights that are extended through these other people. So the idea was April Imholt, I think she talked afterwards, and I don't know what specifically they're talking about, but I think it has to do with her saying that she is a nanny and someone else saying it isn't. And she had already invoked, they had given her Miranda rights, and she's talking. So he's saying that should not be used against him. And the prosecution said, yeah, I think you're right. And I think the deal that they came up with is unless she testifies, then we can maybe produce this as a point of, I don't know, they'll deal with it at that point. That's perfectly fine. And Kurt, thank you. Someone came in here, Kurt of Uncivil Law. So Kurt was talking about this, but even at the time, Kurt's like, am I wrong? So, you were working through this. He hadn't read the motion. He hadn't done all the work. And so the arrogance on the side of Nick is a little bit much, but in his defense, we get very arrogant about him as well. So I get all this, right? So this is the problem that I have kind of with the Nick stuff is he's a dick. He's a complete dick. And it's hard to like someone at some point.
That you have to kind of use as a rule book that exists. And people are just forgot that the confrontation clause exists, and you can't just do an end run around people's Sixth Amendment rights or their Fifth Amendment rights and then try and get inadmissible statements admitted. They don't just let you do that because the person who you're doing that to also has rights, even if they're not directly implicated. And one of those rights is the right to confront any witness against you. But if you can't call that witness because they have a Fifth Amendment right that you can't pierce, the state doesn't just get to use that. And you know how you know this is true? This is the funny part. you know this is true is because they don't just do it all the time, because they just do it all the time. If it worked the way that certain reviewers thought it would work, they would just always do it, because you could always get someone else to make the statements that you need without Miranda, and then just trample on the rights of everybody else.
Now, I would just say here, okay, doesn't mean like he has, oh, this is common. Therefore, now look, okay, then why did you draft the motion? If it's just common and everyone does it, then why did you draft the motion? Even though it's something that's probably going to, and sounds like it did get resolved here, then that's what I'm saying. There's two parts to this, or the side to this, and someone else can be arguing that, and maybe someone would, maybe a prosecutor would. It's amazing the things that people will argue, including some parts of Nick's motion. Anyway, let's keep going.
They just do it all the time. Sometimes about some of my friends, I'm sitting here and I'm going, I know they keep saying that I'm a non-practicing lawyer, proudly so. I know they keep saying it, but I'm just sitting here going, but their analysis is bad. Sometimes I just wonder, like, how much non-practicing lawyer derangement syndrome some of these people have. And I'm like, guys, like, please stop.
Stop
doing bad analysis because you're mad about something. Whatever it is, I don't care.
What are those?
But like,
what are those old-timey urinal things that they would piss in? That's what it looks like he's drinking out of. Okay.
Stop throwing your own integrity down the toilet. That's weird.
I mean,
it's just me.
No offense, but I don't get clients from doing this. I don't know about online integrity.
You don't need to help people hate me. They do it already. They do it for free.
That's true.
They do it for free. They don't need you.
Some pay money for it though.
Like, just calm down. Out there screaming and yelling, like, I can't believe he's doing this. Like,
that was a bit. So I did see Kurt. He went off a little bit. I don't know. He was having a good day, and then he got a little worked up. And I don't know if it was specifically about that. This is the problem. Nick conflates a lot of things. Anyway, let's keep going.
And yet we go in, and the prosecutor's like, yeah. I don't think it was really bad, where he kind of just like steamrolled her Miranda rights, or the reading of Miranda and her assertion of 5th and 6th Amendment rights. That was probably not good. So we're just...
Yeah, you got to think about it, right? If someone, not even a co-conspirator, but someone else in there, and they get evidence that's not in the lawful way to get it, which would be testimony after they've given their Miranda rights, and it can't be used against them. Why is it being used against someone else? So it does make sense.
It's going to let that issue go. So I'm just sitting here going, why do they think this is a motion to suppress? And it's great because they're going through all these analyses, right? And they're like, no. Look, the video's the exact same. Of course it's the exact same. Look, it's...
All right, I appreciate this. Natasha says Kurt was cracking at the lawyer that wrote the motion. Right, and we're going to get there. So a lot of people think that Nick wrote the motion. Nick is going to say, there's no way I did. Now, I saw Legal Mindset talking about his motion to suppress the video, and I thought his analysis was good. And by the way, I've been just fine with Legal Mindset's take on a lot of this stuff. Andrew, I think he does just fine. I think a lot of these guys are doing fine. It's the hate that I know that we've. And by the way, this is a point even for me. I'm like, okay, because I watched a bunch of these clips, and some of them I took in there, and I'm like, okay, look. There is a tendency to hate so much. And by the way, this goes back to the Leo Frank thing, where you just don't like, so if you don't know too much about the Leo Frank thing, he was a Jew in Georgia in the 1913 that killed this girl, and then they went to trial, and then he was very prominent, and then what came out of that was a lot of Jews in the North really made a big deal at the New York Times. Adolf Fox for the New York Times, I'm trying to remember the guy's name, big advertiser. Point is, a lot of money went into this thing to try to rehabilitate, and to 13 appeals, guilty the whole time. Okay, so now the ADL tries to whitewash this system, and they're invested into this because of their tie with the Jewish community, right? So you have to defend at all costs. There's nothing wrong with just saying this guy was a creep, okay? The facts bear it out. It's very obvious he was a creep. Matter of fact, the people that defended him after the fact, they're like, he was so creepy. This is the New York Times, Adolf Fox, who put hundreds of thousands of dollars in to try to save this guy. When he met him, he's like, gross. He gave me the creeps. So, you know what? then that's what it is. This doesn't mean that the whole Jewish community is creeps, but this guy was. But you've got, so with the Nick thing, there's a tendency, we've got, every one of us is gonna like, look, it's gross, the facts that came out, and don't let that taint the analysis that goes forward. I think that's the issue. But then Nick acts like this, and it's hard not to. So, okay. Kurt's all hat and no horse. I like Kurt. Kurt's a smart guy. I think it would be interesting to have conversation with, by the way, I know my place. Okay. I know my place. I'm a house wigger. No, I don't know. I know my place, in my mentality. I know where I'm good. I know where I'm not. I wouldn't go toe to toe with some of these people on certain things. It's perfectly fine. I don't like Barnes, but I think he's super smart. Viva Fry. He's an easy one. We'd all take.
There's no edits here. There's nothing here. There's nothing here. It's like, but what you're doing is you're arguing about the sufficiency of the evidence for a trier of fact. But we're not at trial, guys. We're not even close to trial. We're not asking a judge to rule on the sufficiency.
And let me say this. So Nick's motion says, look, there's a video out there. The guy, the Pomplano or whatever, the policeman, he saw this edited video. And so now Nick's explaining it a little bit better. And we're going to look at the motion perhaps a little bit. And so a lot of people are going, Nick, this is a probable cause standard. It's not, hearsay. It's not, you can get the actual document. You're saying that this was pulled off a line, the video of the night he was all coked up and laced, whatever. And so they're like, this isn't going to work. But Nick does explain it a little here, which I think is better than his motion, his attorney's motion.
Sufficiency of the evidence. Because what you've done is presented an argument as to why this evidence would be admissible. But admissibility isn't the issue. And if you're stuck on the admissibility of the video, I'm just going to encourage you to go back and read the document again, because it lays out that, again, this is a Frank's challenge. The Frank's challenge is about the sufficiency of the warrant request. What if I told you that there's a non-practicing lawyer out there who is representing a client in a felony possession case in Candy, Ohio County, in front of Judge Wenzel, and won that case on a Frank's challenge to a warrant, where the prosecution, or I guess actually just the affiant, the officer who requested the search warrant, lied about having a confidential informant. They actually called them a concerned citizen when they were a confidential informant.
Okay, so let me explain what's happening here. Nick is telling you, without telling you, that when he was practicing law, he's the non-practicing attorney, he wrote a motion, a Frank's motion, which was a challenge, Frank's challenge. Frank's is this. It's, see if I can remember the case at all. Delaware guy goes in, molests some chick. She describes him. He then goes, they want to get on a separate issue. Frank's was kind of being detained, I think, for that. And so officer gets a warrant describing this guy, Frank's, and he says in the warrant, in the application for the warrant, that he had interviewed Frank's boss and some other people at work, and he got this info, and then boom, they grant him the warrant. They go into his place, they find evidence. Gotcha. So he appeals this up. Now, what he's appealing up to the Supreme Court is basically, you lied on the warrant, on the application of the warrant. Therefore, and lying is not good, and so therefore you throw the whole thing out. Now, is it on a issue? And by the way, there's lying. And then there's just, we got something wrong. Kurt described it as, hey, this person's blonde, when I meant to say it was, dark hair, or I know the difference, but it's not material. But lying about it is material. So Nick's saying he wrote this motion when he was an attorney in front of the same judge, and they got the evidence kicked out, right? Or the motion, or the warrant quashed, killed, what have you. He is saying he did this. Now, I'll just give you a little attorney's secret here. You're in a case, someone writes a motion, maybe you've written a motion, some sort of legal brief or what have you, or someone opposing counsel does, and it's amazing. And you see that, and then you have that same before, you're like, hey, I just incorporate some of the stuff they said. Sometimes it's case law that you didn't know, and you do shepherdizing, which is you check it, you find out where it's all at, what the ruling is, and make sure it's the case on point still. And you incorporate that. So you use a lot of your own writing. I oftentimes just use the same stuff I've done for the same issue, different case, put it in there, and then manipulate it up. You're plagiarizing yourself, quite literally, but it happens all the time in law. He's saying he had done, just so keep this in mind, because this is a fascinating little part of this.
If I told you there was a non-practicing lawyer out there who won a case in front of this judge on this issue, which is embarrassing to be worse at this than me. That's the biggest own I can.
Now, notice here, this is a clip, so they're editing here and there. Just take it for what it's worth. It's for the most part.
Matt, how can you be worse at lawyering than I am? The video. You want the video? Like, does the state need the video? It's still there. It's still on Rumble. It's still on YouTube. It was never taken down. Go visit the URL. It'll tell you it's private. It is. But they can easily get that video from YouTube, right? Yes, they can. Why didn't he?
Okay. So Nick is saying it's not the fact that we have a video. It's not the fact that it's not the original video. It's the fact that the affiant, the officer, and I do have, maybe I should pull this up here. I do have his declaration. That the officer himself said in the application to the warrant. Let me see here. See if I can find this. See if I put it in our one here. Search warrant application. Perfect. Okay. I am going to go do this. It's window. Let's do the window. Let's see. It's this one. There we go. Okay. So what I'm going to do here is I'm going to type video search. It's going to give me all the places about where it said video. Okay. Your affiant was able to review the video that was taken off of Nicholas's YouTube and Rumble social media sites. The video is from 5/21/2024 and is of Nicholas in the basement studio talking about court appeals ruling he lost. He appears in the video to be drinking alcoholic beverages and eventually appears under the influence of a substance or substances. The entire video blog is 4 hours, 4 minutes long. Approximately 2:46 into the video, Nicholas leaves to go use the restroom. When he returns at 2:40, he appears to be making an excited look and a white powdery substance on his nose. Your affiant believes his behavior is indicative of central nervous. Okay, we've done over this, and he breaks it down. Your affiant knows through training and experience that ingesting Your affiant also noted that throughout the video, Nicholas is so under the influence of substance that he has to close one eye to read his screen, rambles, slurs. We've all seen this video. It should be noted that your affiant is experience, behavior of Nicholas in his video blog. Okay, so what am I pointing out here? I'm pointing out that the video is that he said he saw this whole entire video. That's where Nick is saying, not so fast there, but because I took it down. It is not public. Now, I don't know what date he took it down, but he took it down. He set it to private. Okay. Now, there is one small problem, which I will get to, but let's keep going here.
Well, they could easily get that from Rumble, right? Well, yeah, he can. Why didn't he? Isn't that strange to you? Doesn't that bother you? Why he would say he got it from YouTube and Rumble? Why he would say he reviewed my video, but then not actually do that? When he could do it easily. Or, better yet, what he could have done was just say that he didn't. He could have just said that he didn't. I watched it from this other place. I found it reliable. Okay. But why didn't you? Why didn't he do that? Maybe he had doubts about its reliability. Maybe it's because cops lie sometimes. Maybe it's because cops lie a lot of the times. But the embarrassing thing is not even the cop lying. Oh, and by the way, I can prove it because we have to be able to raise this challenge. That's the thing. You don't raise a Frank's challenge willy-nilly. You don't go, I'm going to take a shot in the dark. That's why what you actually are doing is asking for the judge to grant a Frank's hearing. And at the Frank's hearing, there will be an evidentiary argument. And we'll find out. We'll find out if the cop lied or not. He did. He did. It's easy to prove. It's easy to show. You have to use the information that they provide in the warrant and through discovery. You have to know. Numero uno Josh Denny fans is it's the same video, retard. There's nothing different on your video. You're arguing the wrong thing.
He's got a point.
That's the best part. You're arguing the wrong thing. And that you can't figure that out is the fault of the practicing lawyers who can't seem to analyze a Frank's challenge. I'm sure I'm just like, of course, because what I did was I just hired an attorney who he would just let me draft.
Okay, so we've got that there, right? The idea isn't that the officer could watch the video and they're talking about the video itself, and it is confusing the way that the way that Nick's motion is drafted there. But if you understand what the idea of the Franks is that there's a lie on the application that's material, and we can look at the Frank stuff that makes it a difference. So the question is, you can't be having officers, and his point, which I say correctly, and I said it at the start, which is, it appeared to me that the officers, everyone had their ducks in a row, but you start getting them lying about something. No, now the bad part is, it doesn't mean that Nick didn't have coke. It didn't mean that Nick wasn't a piece of shit and his house was a mess. All that. It just means why, and it blows me away that I see officers do this way too much, which is, you don't have to do this. Like he said, you could have just said where you actually saw it from, and maybe he did. Maybe I still have a way to save this guy though.
All the motions and everything, and he just signed them, right? Like I've seen that as if, first of all, as if you'd hire someone to do that anyway. But second of all,
okay, now Nick is talking about this motion, right? That he's like, people are saying that I wrote it. He's like, that's stupid. I got an attorney. The attorney would write it.
As if he would forego his ethical obligations and do that is ludicrous. But people just can't figure out why the practicing attorneys who are all sitting on YouTube more than I am, why they're getting this shit wrong.
Okay, but remember, Nick said earlier that there's an attorney in town, a non-practicing attorney in town that wrote this motion, that won this case, and that they should, and he's bragging about that. But now you're saying so you're bragging that you had this case, that you won this, and now you're saying though that you had nothing to do with it and you was your attorney. Which is it? Okay, maybe let's give the most generous in the middle, which is Nick says to his attorney, look, I've won this shit. I know this. Here's my motion. Take this. This is in front of the same judge. Here's what it was. So in a way you did write it, because I don't know, maybe the judge wouldn't quite write it the same way. I don't know. Let's talk about it. Let's take a look here at what some of these people, Kurt has never, to my knowledge, ever tried a case. Could be true. I know he's a patent attorney. ADL, awesome defamation leadership. Yep, absolutely. Kurt is finding his lane with confidence. Okay. The greatest irony is that Nick's legal argument hinges on trying to claim someone else is using ambiguity in a disingenuous way. It's part of that, but if you understand what we just went through here, he's talking, and we just read the declaration from the police officer saying this. Now, let me just show one other aspect here. This is something that I don't know that Nick knows. Okay. This is Nick's, let's take this off here. This is Nick's, because if you go to look for the video on YouTube, it's not there. If you go to look for the video on Rumble, it's not there. Oddly, it's still there on Rumble. So perhaps the police officer meant Rumble, and he didn't.
Ambiguous. Then
there you go. There's our man from that night. So 2 hours. I mean, here it's still up, and look at how fucked.
Jennifer,
you're trying to tell me that he was. That looks like a different person here. I mean, this is bizarre. I mean, look at that. He's like a gremlin of some sort. He looks like he's older than me. Horrible hair, giant nose, just a piece of shit. And it's still up on Rumble, folks. So there you go. It's still there on Rumble. So perhaps it's going to work out. Someone get a hold of the DA and say, hey, it's up on Rumble. He could still say, I meant Rumble. I mean, it's on Odyssey. It's on Odyssey. It's still up on Odyssey. I could still see it right now. And matter of fact, that's where it was. I who knows Odyssey? I mean, they were going through this crypto issue with the SEC. It's hard to tell what it really is, but it's up on Odyssey. And I saw it on Odyssey. So, I mean, look, the way he said it there is, now, could have been this too. It doesn't say where he saw it. So you'll have to walk through this to get it. Okay. Nick is Daniel Larson with slightly better story arc. I don't know who that is. Apparently that's untrue also. I don't know what you're talking about. Sean found the case Nick was talking about. The warrant was good. Nick won on different grounds entirely. See, thank you. And this is what's interesting here, because Nick talks about this, and I just wanted to break through the criminal case and the civil case. Okay, he talks about getting his kids back and winning this case, but then in the same breath, he's talking about this alcohol patch, or testing patch that he's had to do. He's also said the state could not find one person to come and testify against me in my CPS case to show that I was, loaded up on drugs and alcohol all the time in the house. And I'm like, well, I don't think they needed to. They had your test results, which were, you kept pissing positive on alcohol. They don't need that. And the state, you heard that we've talked about this too. The judge wants those kids back with the parents. This isn't but this is why I'm saying is it a case? It's more like an issue, which is, we're going to monitor you. We're going to make sure you're the parents to overcome and to take your rights away as parents. It is not easy to do on a permanent basis. On a temporary emergency basis, it entirely is not that difficult, and the courts do it all the fucking time. But to do it on a permanent basis, it's going to take a lot more, and you're going to have to be an extra degenerate. You're not an extra degenerate. They can see you in court. By the way, the judge can look out there in court and see that you're okay. They look at your test results and they see that you're okay. They ordered an alcohol assessment test, a drug assessment test. They're ordering you still to do drug and alcohol testing. You didn't win the case. Okay. The kids are back. God bless. All that's good, but it's gaslighting us. Okay. Continually gaslighting us. Curtis Sean is asked too many times. Oh, wow. He blocked me on YouTube. Okay. I'm sorry to hear that. Yeah, it happens to all of us. I hope is he back on Hooch? Probably. Dwayne says, Nick is right about one thing. Over-aggressive cops lie and exaggerate. YouTube is full of crooked cops lying and violating rights. Absolutely. And some of the most difficult parties to deal with as opposing parties, typically, I've had a few cops that have actually been just fine, is police and fire. There's this, and I don't know if it's just indicative of what their job is all the time, where they're constantly having to push back and show who's in charge on, like traffic stops or whatnot, but they are horrible people to deal with. They are always right. They're such assholes. It's constant nonstop. They don't care about telling the truth. Is Tyler shopping for swinging partners again? Well, I guess they have to. I know I'm not doing that. I know, again, what are you talking about? If you're talking about me, what we just went through, gaslight. Yes, exactly. Dwayne. Okay, so you guys are talking to each other. Kiwi Farms notes. Kiwi Farms took some notes on the omnibus hearing. Yeah, I saw that. Look, what I'm trying to do here, I'm going to go over some of the transcript from the CPS stuff. We'll wait till the omnibus. I mean, there's more to be done. I think they didn't even rule on his motion to dismiss. There is the motion. And by the way, this is the gaslighting shit that happens too. It's half truths. We've seen too many lies. What I just pointed out there, right there, just in that 9-minute clip, which is, I've written a motion. I've done this thing myself. I'm this amazing non-attorney. I would never write my own stuff. That's what I hired an attorney to do. I'm like, wait, what? It's taken off the internet, but it's still on the internet. So I know he fucked up on that part. So there's and by the way, this is what I on the side eye over here is Nick stuff. Is JC a bot? How dare you? JC is not a bot. How dare you? If I were a jury, I would give Nick the chair the moment he opens his mouth. Now, not the chair, but he needs to do time. Yeah, quite possibly. Popcorn Power says, of course, the videos that get spread on YouTube are the ones where cops screw up. Very rarely do videos where people act normally make the rounds. True. I mean, you got a point. Odyssey. I can't. I'm sorry. You're right. Odyssey. It's on Odyssey. JC is a bot. Is a bot. Okay, so I don't think I want to. Let's go. Let's try to find out some more stuff here. Let's go to. I'm going to bring it in. I went and I redacted all this shit here too, so we should be good to go. but it's transcripts. And by the way, you people, I know you want like omnibus, you want Ethan Ralph, you want this and that. I don't practice that kind of law, so it doesn't help us very much. I need to kind of do this all. Could Nick be executed for cuckery? Follow-up question, should Nick be executed for cuckery? Quite possibly. I mean, okay, so here we go. Remember, I was on with, let's take a look here. Sorry, I'm clicking the wrong button. Fox and Friends coffee, go there, put in the code review. You get 15%, I think it's actually 18%. He stopped sponsoring me. He was sending me coffee, but I still like to push his stuff and buy it. So go there. Remember these shows I was on? I was with Andrew, Liberty. We talked about stuff there. He came on my show, and then I do other things too. I do these guys are both wrong. Dave Smith and this Andrew guy talked about family law. Now, I don't know if you guys can read that there very well, but I am going to try to read it. This is the best I can do. So, sorry, this is where we're at. Okay, Mr. Rekieta. Any other? Now, this is the end of the CPS emergency hearing. It's the defense's side, and we have some transcripts there. We'll try to get through it fairly quickly, and because this is more along the lines of stuff I do. The sheer number of bad cops shown on YouTube should make you squirm every time you have contact. Look at Karen Reed case. I agree, and I don't know what you guys tell your kids, but we definitely tell ours. My wife watches a bunch of crime podcasts too, so she's always like, "Don't fucking talk to the police." And Nick talked to the police. Okay, let's see if we can read this here. Mr. Rekieta, any other witnesses, Ms. Weber? In the matter of welfare of the children. Okay. Mr. Weber, no other witnesses, the court. Mr. Mueller, no witnesses, the court. Mr. Greiner, no, Your Honor, the court. All right. Then Ms. Pierce, any comments then about continued out of home placement? Ms. Pierce, Your Honor, the agency is requesting continued out of home placement. There are no conditions that could be ordered today that would allow the children to safely remove to the home. There have not been, and there are no services in place or that could be ordered to allow the children to safely return home today. It's an option to order that the grandparents or current foster parents move into another home with the children at this point. You heard that both from the agency, from the guardian ad litem, and that it would not be in the children's best interest and there would be continued danger. By the way, that's his second house. He has a second house. I don't think that's what they're talking about. They're basically saying move the grandparents into the actual house with Nick and his family. The parents came in there and cleaned. I think. And I will give the defense of the parents a little bit, which is they're saying Nick has never done drugs. He's still got this criminal case going on. So you've got these two competing factions. You're trying to get your kids back as quick as possible. And you're doing what you can for that, which should be important, but you can't blow up the whole criminal side too, because then you're going to be going to jail. It's not an option in order the grandparents or current foster parents move into the home with the children at this point. You heard that from both the agency and the guardian ad litem, that it would not be in the children's best interest, and there would be continued danger. We have a home where there was a significant amount of controlled substances located. Okay, this is going to be a pain in the ass. Located, children tested positive and had high test results. We've been able to form a safer plan. We've not been able to have a period of sobriety, which is absolutely necessary before there can be a reduction in the visits or talking about moving home. So this is my theory, which is Nick's had sobriety, so which is good. And by the way, I think that's really true when you watch him and that stream, and he had that big urinal thing that he was drinking out of, and he's just all the time doing it. He's got this fixation. He's trying to take the place of his coke and his alcohol and his addiction issues. And I think this is just me just BSing, but it's a little it's like he's chugging that thing multiple times and it's a huge jug. I don't know where he pees, but that's somewhat problematic, but I think that's the case. He's sober and he's doing what he can, and hopefully he gets through this. So we're asking for your continued placement of the children, like care, custody, and control, transferred to Candido High County Health and Human Services. that it's in the children's best interest that they would be immediately in danger if they were released to their parents. That supervised visitation continued directly by the agency with input from the guardian ad litem. And I believe at the last hearing, Judge Manson ordered some 42.09 factors. I'm not sure what those are in Minnesota. I'm not sure if those, but we would ask that those continue to be in place. Essentially, that the parents, it might be something like they have here, which is requirements for the supervised visitors that they follow certain guidelines, that they would, notify authorities of something else. But basically, your idea is the kids are paramount, protect them over the parents. Okay. Undergo chemical. Okay, here we go. That the parents would undergo a chemical use assessment and follow the recommendations. And I told you about that, which is an expert comes in, has a discussion about their alcohol use, it looks at, talks to people, and basically then tells the parties, here is your level of addiction. Here's what you need to do to go forward. And it's an assessment, and it gives recommendations. So the court could then say, okay, you need to maybe go to AA, you need to do X, Y, and Z. And they can order those things based on, what are the parameters in those counties and what's the assessment. They would not use any controlled substances. And he has like a patch thing on his arm that tests him all the time. So that's pretty invasive, actually. They would not use any controlled substances, not prescribed alcohol, and they would submit to random testing at the request of the agency or the guardian ad litem. And they would sign any release for the agency and the guardian to monitor these conditions, any placement, paperwork. All right, I'm sorry. I got to change this in 2 spots here. All right. The court. All right. Miss Barber, any comments you have? Thank you, Your Honor. Oh, I'm sorry, Miss Pierce. Do you have some more? I did. I would just ask for clarification that there would not be, they would agree not to revoke any of those necessary releases as well. Remember, Nick and his wife, they tested initially, and then they wouldn't release the tests. Says something, but once again, he is protecting himself. But here's where the gaslighting comes in, because he talks about how he's clean and sober. I'm doing this and that. No one can testify that, we were hammered on drugs all the time. It's like, well, I don't know. Your drug test can testify. Your drug, you were still taking alcohol when we were talking about you were still testing positive for alcohol. So those test results that you said, they could testify. You don't need to have, once again, this family court doesn't need to have people coming in and talking about what a degenerate you are. They are not concerned about the long term. They just said, get your shit together, start testing. We can monitor you. Once we have a little bit of that trust there, or we have ability to control, then we're good. Your kids should go back. I get it. Now, that doesn't mean that CPS aren't awful, that they're not just as bad pieces of shit as the cops or whatnot, but stop it, Nick. Okay. All right. I apologize for interrupting. That's right. Miss Barber, I don't have anything additional from my testimony. I always ask, and that was their stutter, not mine. I always ask the court to make the safest plan for the children. Thank you. Yeah, the safest plan for the children may not be the least invasive or the one that the courts want to go with, because you are overprotecting and the parents are underprotecting, and we're probably going to go somewhere in the middle. All right then, said Miss Weber. Thank you, Your Honor. Well, there's been a lot of testimony and there's a lot of concerns about past safety in the home, but as of today, it's just a lot of speculation. No one's actually been able to point to any drug use by the parents. There's no drug. Okay, so I appreciate the attorney making these points, but there were drugs found in the house, and it's that is part of it. So you have possession. We haven't dealt with how it got there. He being Nick is going to complain that there is a warrant problem, that they never should have been there. Therefore, you're kicking all this out, possibly. But even the court, they understand all this, right? Which is, you don't live in a drug den now. The parents cleaned it up now. There's a lot of social works coming in through now. We're going to get you to a place to have these kids. That's the goal. And obviously we know that because that actually happened. Okay. Thank you, Your Honor. Well, there's a lot of testimony. Like we said, this is me saying this. But as of today, just a lot of speculation. No one's actually been able to point to any drug use by the parents. There's no drugs currently in the home or paraphernalia in the home. Yeah, because the cops confiscated it, dumb fuck. We heard from Miss... it just flipped on me here. There we go. We heard from Miss Barber, and I think I need to change it here. I don't know if you guys even be able to see this. There you go. Barber, I know Miss Sweep had allowed something able to something areas of the home, and Mr. Robert Rekieta, the dad, the grandpa, has also testified that he has not seen any drug use by his son or even intoxication of his son. We know that's not right. All right. I mean, you're telling me you never, I think it's well known that his dad would watch his streams. You're saying this, you didn't actually get curious to watch this video. You've never seen, maybe, and not in person. Is that how you get past the lie? Maybe that's how you get past the lie. Okay. Of the parents, as far as, okay, no, he's aware of seeing his non-parent. He's not seen any unsafe parenting, and he feels very comfortable with the children in the care of their parents. Okay. As far as Rule 4 assessments that were ordered, I would, under the circumstances, I think we need to take a very strict look at the assessments. And I have not seen the order from the last, this is great talking, the first hearing with the Judge Hansen, and maybe I missed it, so I apologize, but the chemical use assessment, you know, Mr. Rekieta has not, there's not proof that he's used. I mean, there is probably proof, which is that first test, right? If they want an assessment for chemical use, I guess, okay, but there isn't going to be anything he hasn't used. That's not what the assessment is. The assessment isn't say that there's nothing there. The assessment is, you perhaps are the kind of person that shouldn't be drinking alcohol at all because it's going to turn into something. We just saw Theo Vaughn interviewed Mr. Donald Trump, the president, and he said, Mr. President, I can't take alcohol because I just have an itch that I had to scratch, and that scratch is cocaine. So we understand those kind of things. As far as the mental health assessment, Mr. Rekieta, any reason you couldn't do one of those diagnostic assessments at Woodlands or whatever? Mr. Rekieta, I have no trouble doing any sort of assessment like that, bitch. So he's willing to do a mental health assessment. That's good. We just saw him on stream, and I don't know. Does this look like does that look like a guy that's mentally healthy? Good. Ms. Weber, okay, as far as the drug testing, Mr. Rekieta and actually Ms. Rekieta as well have already started doing some drug testing at Minnesota. Bear with me as we change here. Minnesota monitoring, we would offset these, and I realize there's these just, I think, quick reports. They haven't come back with the lab with the levels, but we would like to offer these if there's agreeable to do the show that our clients are doing some drug testing. Boy, it's a lot of words to say a little bit. And as far as release of information, here's the problem is that whatever. Ms. Pierce is not only the attorney that's assigned to the Chips case, she's assigned to the criminal case. Dun, dun, dun. She's not giving my guy any use immunity at all on this. Potentially that she finds here, potentially what she finds here could be used in the criminal file or a comment that he makes. That's interesting. So I get that, which is there's a little bit of a crossover here. There's the DA, I guess she's also working on the criminal side. That's and the prosecuting on the chip side. Yeah, so you don't want to release these results. Why? Because they're proof that there's drug use. Otherwise, you would be doing it. Let's say you were clean, right? Completely clean. And it's not your daughter that got a bad test. You're completely clean. You're like, yeah, fuck, take this. I see this all the time, which is one party, you're trying to get them to do a drug test, and they're like, well, fine, then he or she, they have to test too. And that it's usually the other person's like, yeah, of course. Of course I'll go test. That's not a problem. I'm not the one with the problem. And then they go test and the other party doesn't. And so it's very common. As far as releases, okay, she potentially, Mr. Rekieta is an attorney. Oh, hey. Non-practicing. It didn't say that in there. So evidently he's still licensed. And he knows the rules, and he's being super careful, and he and his wife are being very careful about. And by the way, I'm not saying you need to just give up your rights for all this, but we know Nick tested hot. Okay. So yeah. And I could say that because if you didn't, you're released. They're very proud to release all the results after that, right? Not the first one, but they're very proud to release. Look at all these ones you're done. Okay. So, I mean, which is it? You're going to say you're good, you're bad. You want them. Here's all my results. Oh, but not this one. No, that was a while ago. They're being very careful and not saying anything that could possibly be used against them. Well, he talks out in court. I mean, you just the statement that Miss Sweep heard about, the one in the hall. Well, quote, well, these are consequences of our actions, unquote. And right away, that's gotten blown into out of proportion. We don't even know what the context that statement was about, or even the entire statement. The point is, there's a lot of potential for misuse of information. Then that's why Mr. Rekieta and his wife really need to be very close. Okay, hang on. Handle on what information that they something is going forward. And I know that it's just so incompatible with child protection cases. That's a short timeline. And in some regards, I feel very stuck trying to help my client get these kids back as soon as he can, not without some type of guarantee. And what is released, and in this case, won't make it into the criminal case. And I have to say that, and, he's just sitting there probably going, oh, what are you fucking talking about? Would you stop mentioning that it looks like I'm guilty? Make it into the criminal. I have to say that, we'll do the assessments. Mr. Rekieta can continue doing the testing and provide those three results to the county to show the sobriety. He's still doing them, and he's proud of those results. Other than that, I think it would be good to have some environmental education on cleaning the home, because it seems to be an issue. But other than that, I don't know that there's anything that I can safely require or ask that my client do. The court. All right. Thank you. And did you want to submit those as exhibits, the Minnesota monitoring? Yeah, we can do that through modes. It must be one of their online things. So there you go, which is, he doesn't want to, once again, this test we don't want. These tests we do want. Matter of fact, we want to submit them as our own exhibits, but we don't want this one over here. Let's not. Because he hasn't, there's no proof. There's no proof that he's tested positive as long as we don't submit these tests, the first ones. Okay. The court, any objection to those, Ms. Pierce, to the Minnesota monitoring test results? Do you have copies of those? And let's go to the next slide. Ms. Pierce, I did get a copy of those tests. I guess I would also offer the child's positive hair test. Oh, shit. All right. Do you have copies of those I can, so that we can receive them, or are they in modes? I can. We can have them marked, and then may I approach? Ms. Weber says. Yes, the court says you may. So this is Mr. and Mrs. Rekieta's. Then Mr. Mueller says, the parents' Minnesota monitoring were offered to the county and the guardian ad litem this morning. Drug testing of the baby or the younger child was offered to us yesterday. Baby. I don't think it was a baby. The court. All right. So then I will receive those. Something will be the Minnesota monitoring testing. 001. That's the exhibit number 1. Exhibit 2 will be I'll make the testing of the child. All right. Then Mr. Mueller, any comments that you have? Mr. Mueller, everything that Ms. Weber just said, ditto. Who says ditto in court? I would also like to ask the court to consider lessening, maybe that's what it said, the restriction on the visitations between parents and the children. If I understand correctly, they're supervised either at the agency or the memory visitor center. I don't know what that word is. I believe that's utterly ridiculous. These parents could go over to their parents, either their in-laws or the parents of the case maybe, and see their children in that setting, supervised by the grandparents. As the Griner pointed out, you've got decades of supervising and knowing what proper parenting is. I don't know. Do they? I mean, look how their kids turned out. They should be allowed to act as a supervisor of the visitations between those parents and the children. That's all, Judge. Mr. Griner. Go ahead. Mr. Griner, Your Honor, I looked at my electronic case management system, and this hearing is titled an emergency protective care hearing. And I think the it's so fundamentally important to remember that the issue of the burden of proof that the county has the burden of establishing the emergency. The parents don't have the burden of proving the safest option by having to submit to random UAs, etc., for 40 days. So, as a starting point, it would seem obvious that the state demonstrated that an emergency existed on May and is in the form of cocaine being found in the parents' residence. Was then, this is now. That was then, this is now. Okay, that's a good legal term. Today, June 6th, there's no evidence of any emergency. And in fact, everything is suggesting, including a negative UI from yesterday. Once again, these are tests we will like. These are tests we want to submit are fine. But then don't shut up with this never tested positive or used. There's no evidence of him using because we won't let you see those results. Including Ms. Barber's walkthrough today, and that there's not any ongoing drug use and there's not any drug present in the house, that the clutter was seen present, was making it difficult to walk, has been rectified. Sweet. Good to see they adulted their way up. There was, so I respectfully disagree with the county's position that no conditions ordered today would allow for the children to be returned home safely. Obviously what seems the county is going from in here to demonstrate to us to prove up the emergency. We don't have to prove a current emergency today. Rather, the parents have to prove that they have been abstinent for a minimum 30 days, probably 60, for an emergency not to exist. Well, that's just not the standard. And I think it's implicit in what they're arguing. So yes, these conditions that could be ordered today, we have a very sophisticated, very credible grandparent who testified today that says he will, and his wife will be present to make sure there's no trouble, and in fact that something will be the first to make sure that his grandchildren are removed from that. And that's given him credible assurances that the children will be safe and that they go back to the parents and home today with grandparents overnight. I think, Miss Pierce, Your Honor, sorry, can I interrupt for a second? I just noticed that there's 9 participants on Zoom, and then they boomer themselves out here talking about Zoom, and then they figure it out and they say, oh, okay, that's fine. And I'll get to some of your questions here in a second, or comments, or hatred. I don't know. Thank you for that, Ms. Pierce. Okay, go ahead, Griner. Anything further? So my win. When the county's going so far as, well, grandparents can't argue that the children will be safe when they're asleep because the parents who otherwise love them all day and night might be able to access them, seems far afield of what we should be focusing on here today, or whether there's currently an emergency and whether the county's demonstration of that or not. I would actually agree. I don't think that Nick and his wife were overly aggressive, putting the kids in danger. They were neglectful of their parent duties, cleaning up the house, being parents of these kids, leaving cocaine around. That's the kind of thing. So I think you're right. Nick's not at all interested. He's interested in streaming. And banging April. He's not at all interested in going bothering the kids at night. That's not going to be the problem. That's not the problem. He's not sneaking into their bedrooms. I believe that is correct. And therefore, maybe the judge did too. To continue, I also see that, the basic safety plan grandpa is central to, that grandma as a practical matter, then it itself just proves any emergency. Add to that random UAs, must be urine analysis, and chemical use assessment, if and assuming the parents are willing to do that. And any notion that somehow we still have an emergency ongoing is just not correct. I think it's also important to note that the children feel about this. They feel so strongly that they want to go home because they want to be with their grandparents. Their parents. They think it's safe. Well, okay. They don't know any difference. This shithole is all they've known. They don't know any difference. They believe they've learned their lesson. Oh, what lesson would you have? That is fascinating. The parents have learned their lesson. According to Nick, no one's tested positive because they can't prove anything. There's nothing been done wrong. This is all the government conspiring against him, but they've learned their lesson. Okay. I mean, now granted, this is not testimony. This is the attorney talking, but he's advocating for them. So, you know, it's a bit much. They think it's safe. They believe they've learned their lesson. They've been making a lot of improvements, cleaning the house. That house, by the way, the house might have been bad enough to, you know, put him in jail. And that, as I understand, grandparents went through with a fine-tooth comb. Damn, how embarrassing. Your kids are there. 3 of your kids are in there watching you in court. That's embarrassing. Your parents have to come and clean your house. That's embarrassing. They absolutely love their parents. That's positive. They miss their parents, as they should. Blank specifically saying that 80% of her stuff is at the house. Her frogs are there. Blank, the oldest, misses his pets. Okay, miss your parents? In fact, I think all the kids do. Their cats, and then they say, should we dox the cats' names? Lion, Button, and Ninja, and their dog, Sunny, or Pug. Sorry, Pug. But I think the most important of all, these children have been born and raised something their parents, and they tremendously miss their parents, as they should. And it's extremely traumatic for them to be separated something with the prospect of being returned maybe in 60 days. Yeah, that's why you don't do shit that's going to put your kids in harm's way, or anything that they can't look at you and think nothing but heroic, the person that's going to protect them. Same with your wife. I mean, it's a daily routine of making decisions so that your wife trusts you, so that this is the way I work online too, right? People come into your DMs and whatever, and I always act as if my wife is reading these DMs along with me, which means oftentimes it's a lot of racist humor, but that'll only turn her on. So did I say that out loud? Maybe I shouldn't have said it. There's no way that they wanted to start their summer. Obviously, being removed was an extremely traumatic experience, and in all of itself, extending it even one minute more longer is a continuing of trauma that we just don't want to have. True. I completely agree. The balance test you take at this point, and I don't think it's actually in the law here, but the balance you're going to do is there going to be more harm sending them back or keeping them away from the parents, right? And you try to err on the side that the less harm that's going to be long-term. And at this point, I think, you know, it's probably sending them back to the parents is probably the better thing. So Blank, from his perspective, this is the oldest child, is saying that specifically he will be watching for any signs of trouble, that he is a part of the safety plan. If they were seeing any sort of inappropriate behavior, are going to be working with grandpa and grandma and grandpa. So grandpa, grandma, and grandpa. I don't know where the other grandma is. And he will raise it with the issue with the grandpa and to head to making sure these kids stay safe. Oof, that's rough. That's rough and that's sad. Your kids should never be in a position that they are having to look after you, unless you're in an old folks home and you're shitting your pants like we did with my father-in-law who passed. So, and he wasn't in an old folks home. He was in his own home, which it was old. I mean, he was an old folk. So I guess technically it was old folks home, but that's kind of demeaning to his younger wife. So all of these things, we don't think we need to demonstrate, have the burden of proving the appropriateness here, that it's in the best interest of the children to go home. But I think we have. And certainly from our perspective, the county has not demonstrated adequately the standard to continue to keep these children out of the home. Thank you. Okay. There we go. The court. All right. Thank you. Thank you, everyone, for the arguments. The court is going to find that the court takes into consideration the overriding interest is the safety of the children. And the court considers that in its determinations. The court is going to continue to find that there is a prima facie case, prima facie showing, that means just on its face, that there is a juvenile protection matter and that the children are the subject of that. And by the way, that's kind of what it is. It's not like you win your case. It's just like this is continuing until we get a little bit more confidence because it's a small portion of your life that's going to be hampered by this. And the county is going to find that there is an immediate, continues to be an immediate danger to the children's safety, health, and welfare if the children were released to the care of the parents. And I base this on the facts that the testimony and that the child did test positive for cocaine, and that the parents have revoked the releases so that the agency is not able to monitor or to monitor the release, revoke the releases to the Minnesota monitoring so that they can't even get the release or the results. And for those reasons, I do find that the children are continued to be immediately endangered. Note that. That's the key part there, which is if you had released, and by the way, so it's hard to go in with Nick completely and say, because we've seen the video, right? I'm sorry. Aaron Himolti has talked about this, right? And if you take his word at it, whatever. But it all says there was a test result that literally the judge is saying here, if that was clean, then you've tested immediately after. The kid had coke, okay, but we'll probably say it's a bad test. If you are releasing your results and you were clean, this is probably all going away quickly, right? It's not an emergency. It's nothing to hold you on. Now, we could argue till the cows come home about what the locales, whether or not the government should be able to even do this. I get it, but this is the situation we're in, and here we are. So if Nick is going to go into this and say, I'm doing this for my libertarian beliefs, not giving in. Okay, well, sometimes your family, I do all kinds of things against my beliefs to make sure my family's safe. Okay, the court is going to continue to find that there's a prima facie case. We said that to immediately endanger, and I will continue to find protective care with an agency is in the children's best interest with the placement with relatives. I find that the agency is making reasonable efforts to prevent out of home placement, but those efforts have been suppressed by the parents in this case. Specifically, if I'm speaking now, okay, Mr. Rekieta. So I'm hampering. So by hampering those efforts, by revoking the releases and not submitting to the testing as required, and having access to the home, I'll order then that under the 40209 factors, 4209 factors, I'll order that the parents complete a chemical use assessment and follow the recommendations, and that they abstain from the use of alcohol and controlled substances, submit to testing, sign releases to the agency and the guardian ad litem to verify that, and then just a reminder that at any time the parties can bring a motion to reconsider that if there has been cooperation or if there has been other sources that would allow for the safety. I believe that the grandparents are a good resource, and I encourage the parties to look at the possible. And by the way, did you notice that Mr. Rekieta was trying to interrupt up there when he says the parents have been suppressing the issues by the parents of the case? And he's like, shut the fuck up, Mr. Rekieta. I commend and I believe the grandparents are a good option, creative options, but at this time, unless there is verification of testing and verifications, I do not find that it's safe for the children to return home at this time. Then we'll move on to the admit, deny hearing. I do. Mr. Rekieta, Your Honor, may I make a brief? Oh boy, what's he going to say here, folks? Statement to the court. Let me see. Am I on the right page here? Oh no, let's go. You guys are behind there. There you go. Statement to the court. The court. Not at this time. We've been here for 2 hours, Mr. Rekieta. I want to move on. So you don't know what the business of it. Mr. Greiner, I would ask for clarification. The children are asking that at the very least that they have visitation in person with direct supervision of the grandparents without the necessity of harmony or the agent of the county, the court. At this time, I'm going to let supervision remain as in Judge Mason's orders, which is through the agency. I don't see that anything has changed truthfully since Judge Mason's. In fact, there has been revoking of releases, and I'm going to leave it at the discretion of the guardian ad litem and agency. I do note that for McKenna's law that have the children sign McKenna's law, but I will read that. Okay, then they go through, they want a lawyer, the court. I will read. If you want to do a formal advisory, that's fine. They want a lawyer. He has to do the formal advisory. All right. This is between Mueller and Greiner. The court, I'm going to read the new. Okay, so then they go through this advisory. I don't know that we need to do that. McKenna's law is kids 10 years and older, they get an attorney. So they read them their rights. You have a right to go to court, blah, blah, blah. Do you understand your rights? No response. I think they shook their heads yes, because that's what kids do. They don't necessarily speak up. Then is there an understanding as to you want an attorney? Is that right? No audible response. All right. Then he must have said yes. And that's admit, deny. Mr. and Mrs. Rekieta, I see from the file that you received a copy of the petition that was served on you. Is that right? And you understand you had a chance to review it? Mr. and Mrs. Rekieta, yes. Now remember, Nick said they didn't have that. Now, I don't know if it was between this and that, but you got to have that. We talked about that before. I think it's just bullshit. All right, then let's move on to the admit, deny. Mr. and Mrs. Rekieta, I have seen from. Okay, we already said that. The court. Okay, and I think the last hearing they went over your rights and verified that information on the petition as to the children was correct, except for I think the date of birth. So they go through a few little statistical things here. Ms. Rekieta, there should be okay. The name. All right. Then as to the admit, deny, Miss Weber, how does your client want to proceed with an admit or deny? Miss Weber, do you want? Oh, I'm sorry. We are entering denial. All right. Same here, Your Honor. So they enter a denial. Okay. So let's see. They set something for August. Wait, I'm sorry. That's fine. So July 10 at the early 10:30. Okay, so they set and then we have a trial would be July 11 through 26. I heard July 10. So that's what we don't know about is any result. I mean, the kids got sent back, but I would like to see the trial transcripts and all that too. Yeah, pre-trial keeps going on. Is there anything else we need to get out of this? 8th through the 12th. We're on a different date. I would suggest mediation. Okay, Ms. Pierce, any other counsel? Do you want to have some sort of informal family meeting? I would suggest mediation. Okay, well, maybe. We're trying formal mediation. Formal mediation? Okay, yeah. Ms. Pierce, for settlement purpose. Ms. Weber, formal mediation for settlement. Mr. Greiner, in person? Ms. Pierce, it doesn't matter. Ms. Weber, I don't think it matters. Mr. Greiner, okay, I'll order that. I'll order formal mediation. Okay, so maybe they can resolve it out in formal mediation. Do you have a date? Okay, then they keep looking for dates. This is just a bunch of bullshit. Let's get to the end here. I do believe, Your Honor. Oh, I guess anything else for today? Did I miss anything, Ms. Pierce, while we're waiting for the trial dates? I don't believe so, Your Honor. Oh, I guess I would be requesting a protective order for discovery. No objections. Okay. Do you want to normally submit these? Okay. So we go on here. They're getting a court date to return. I'm sorry. There's a lot of this I just don't really care to go over. We kind of got to the meat and potatoes of it. I think we're done. The court. And he's nothing further. The matter's adjourned. There we go. There we go, people. Matter's adjourned. Okay, so we got a lot of stuff here. Maybe we'll go backwards. Some emojis from Iron Face. Okay. How much have you contributed, Tyler, to Aaron's goal? 0. I don't really follow much of that. How old is Nick's unicorn? Oh, God. Nick is a handful for adults. There is 0 way a 16-year-old child can stand up to Nick's gaslighting, guilt trips, and controlling behavior. Look, so here's part of the deal when you say with the kids like this. They're not going to be. They weren't saying this in a way to basically what they were arguing. The attorneys were arguing there is, look, let's at least have supervision at the house. Let's return them there or whatnot. The grandparents will still be around, but the kid's going to call out dad if there's a problem. It's just it's tough. Maybe I need to go up here. Sorry, you guys said a lot. Okay, sure number. Okay, we talked about cops. Talked about when we read about the 16-year-old being a part of the safety plan, we know how Nick treats adults and authorities. Just think how controlling him is. Yeah, I don't know how he is as a parent. He's now dry drunk. I feel bad for people around him. Could be. Hit the like button or else Tyler will have to use his Baldo. Scary, but yet true. Very good. Have you heard them term dry drunk? but I don't understand the implications. Are you just mean and angry all the time? So I did have a client that went through that, and basically, yes, there was a lot of anger with this person, and that they had been sober for years, and that's kind of the term that there's different stages for different people, and that sometimes these people are like, this one was a lot of angry, right? So a lot of anger going on there, and you really need to get to the bottom of it. And I will say this, everyone's different, but a lot of people are either looking for something or they've got some other, mental problem, and they're self-medicating. The self-medication doesn't help, right? So I think I don't know. I'm not an expert on this one. Throw our host one thumbs. Yeah, come on, people. Get CPS awful. CPS control meant staying with and the grandparents. Question: does anyone know why pineapples are a sign of swingers? I think it's upside down pineapples, by the way. Don't put the TV show Psych into disrepute. It's basically all the behaviors that came with his alcoholism without the cathartic release of actually drinking. Perhaps. Let's try this again. CPS awful. CPS control meant staying at the grandparents. I don't know. Maybe you're answering someone else's question there. CPS can be, I've said this over and over. CPS can ruin your family, or they can save it, right? Or save kids. And you just never know where they're intended. It's government workers. I mean, the saying goes, you take the alcohol out of the fruitcake recipe, you still have fruitcake. Okay. That's funny. Don't know about the pineapples. Saw that on Meme Copium. Yeah. He's been doing good stuff too. You should really read the Kiwi Farms Omnibus hearing. How about next week? I appreciate that Pimp Poppy. I did read it, or maybe Meme Copium read it. So other people are doing it out there. And by the way, check those other shows out. There's a lot of good stuff out there. The implication that Nick is in denial of his addiction issues and hasn't received any therapy to address them, and most of all, self. Rekieta dad, he's a good boy. He done nothing wrong. Yeah, exactly. Nick's dad playing CYA. Were there DUI charges? No, I don't think there were. I think there's an issue of way back that there was DUI, but nothing here. Remember, the day of the arrest, the cops pulled him over, and they then took him to the house. There was nothing in the arrest about a DUI at all. I thought he didn't test high because no charge when they picked him up. Yeah. The hair test, though, that's what he didn't release. He did a hair follicle test. That was initially done. He and his wife both did that. All the kids were tested. The hair follicle test, that's the one that came back positive for cocaine for the child. Those are the ones that were not released. Since then, Nick has been doing piss tests, which we read about it on one of the first hearings. He pissed hot for alcohol. So, whoop, whoop. Nick really wants to see the kids unsupervised so he can coordinate their stories so the kids can cover for him. That's a good look. There's a few things. One is just the supervised thing, having your kid. That's traumatic. I just think if I had to do that with my kids, that would have been horrible for them. Kids will get through it though. My other step kids, by the way, we're working on the adoption stuff. We got verification on that. Their dad did have supervised visits, which he failed on all the time. And they get through it. They're fine, but it's not a great situation. But you make a good point. Hey, we got to get these kids. Now, are they going to use them to testify? I don't know that it's really much. What are you going to have them testify to in the criminal trial? I don't think you need to have that. One, if the warrant stands up, the drugs testify for themselves. Can the original test be used in the criminal trial? Well, they could be, but they've got to sign the release of it. So there might be an issue of getting around that. I don't know. I don't do the criminal work, but maybe you can. I don't know. I don't know. Yeah, it's a good question. That's a really good question. However, it doesn't matter, right? It kind of does, but it doesn't. Which it would be odd where he's like, yeah, I tested positive for cocaine, but I didn't have it in my house. I mean, that's the problem Nick's going to have to get past, which is there was cocaine in your house. And it's not, the charge in the criminal side isn't that you had cocaine in your system. It was that you had possession of the cocaine, okay? In a certain amount, 26.2, I think, grams. and a bullet and then guns and da 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 da. So there's not a charge of you were high or that you were tested positive. That is indicative of a behavior of someone who, this is the behavior that is indicative of someone who does have possession of the drugs, right? But you already got the drugs. So I don't know that it's necessary on that point, but good question. I'm not trying to defend Nick with any proof here, but the cops talking about a house with 4 kids being messy kind of pisses me off. Right. Look, Iron Face, thank you for that question. And when it first came out, that was everyone's concept kind of thing. However, according to the social workers, according to a lot of the people that we've seen the testimony in this, that place was a pigsty. We talked about it here in the transcript where they said where it was to the point where you couldn't walk around, it has been cleaned up. And then we've, whether it's reliable resources or not, but Aaron Multi and others have said it was bad. So yes, it's not like Barnes and Viva Fry who first said, hey, you have kids, it gets messy. No, that's not what we're talking. Hey, by the way, it goes beyond that because we saw that and if this is true, once again, if you saw body cam footage, you ferret all this out. The kid's saying, I haven't had clothing in like 5 days. Okay. Let's get done here and then we'll be done. It's been an hour and a half. I would assume a normal mess for those kids. It's not a normal mess. That's the point. And I'm taking it from the testimony. And once again, body cam, you make good points, but we'd have to hold out in that until we get to the body cam footage or whatever. I can't believe how many streamers are grifting Nick's story. Unreal. Absolutely. That's why. This cracks me up. What did Nick do online other than grift in a way, that, if you want to call it that, the whole issue of legal cases and breaking that down and made a ton off of it, right? And he did well. I enjoyed him. About a year ago, I stopped. It was just horrible. I couldn't watch it anymore. I'll just say the clips I saw, even though he's unbearable, I enjoyed them much more now, the recent ones, because he's getting back to Nick, which is not high, not druggy, and it's been much better. But you can't say, oh my God, a baseball player, a former baseball player is now making money as a commentator. How dare he do it? And I'm like, fuck you. Yeah, of course we're doing this. And basically, it's my job. I'm an attorney. And that's why I'm trying to stay in my lane. Talking about CPS stuff, the family law stuff. That's what I do. Yeah. And that's what Nick's done in the past. But you know what? We're fine with people. Yes. And by the way, yes, it's more fun to do a show about something that people care about than not. And you're here. Our cat's here. Aquanet's here. There you go. 2 kids are a whirlwind. 4 are a hurricane. Almost every time I talked about industrial air filter sponsors, we were talking about the mess the kids made. Let me give you some input here. I have 4 kids. 1, 2, 3, 4. Our house is now one of the kids is a mess and he's a teenager. It's a problem, but you know what you do? You just put your foot down and you don't. I'm sorry if you saw my house is clean constantly. We have now without giving away to it, we have 2 floors here, right? And I put in new flooring, 2 stories, okay? And we have Roombas that literally run every day, and they can't do that if there's clothing around the house. It's not difficult to teach kids to put clothing away, and it's more difficult to do some of the girls to make them. But yeah, that's not an excuse at all. That's parenting. Okay, so we'll just move on from the mess. So we don't need to go because can't rely on someone talking about that. Nick has a handful for adults. There's 0 way 16-year-old child can stand up to. Okay, so we talked about that. Now we're getting down here to where I was. I doubt even the grandparents can deal with Nick's manipulation. I don't know. Nick made a great point online. You only see him online, right? You don't know the truth behind the scenes. I'm like, yeah, but you are telling a lot of stuff online, okay? And then you're telling us what you want us to see. So I get it. But then when this shit happens, here we are. Nick has a stay-at-home wife, a nanny, and a hot wife. No excuse. Yeah, exactly. That's reasonable. Yeah, I just want to see pictures now. Oh, good to say. Stay-at-home wife. Yeah. And in fact, look, and I will, for Nick's point of view and everything else here, we don't know all the facts, but we are seeing some of the things, and I'm just trying to break them down. I'm trying to give him some sort of leeway, but it is some shit. This is my state from the beginning before we knew any of this kids on coke, the warrant. What I said was, when you are doing things to put your, as an example, I've been divorced. My wife's been divorced. So I've been single for a while. And then, now we're married 12 years, but there's times in between there where you have your kids, cause I had 50% custody. And, when you have your kids, you just don't do shit that's going to put you in danger, because it's just you are responsible for these kids. If I get high or something happens and then I pass out, or, who's going to, you have to think differently. And then you get married and it's like, okay, you and your wife could drink. Maybe she drinks and you don't, because you got 4 kids in the house. Okay. But I'm not bringing drugs into the house. There's a lot of things you do as a parent that shore up multiple things, which is their safety, your longevity. The government sucks. I don't want to give them any right to come into my house. They don't have any way to get in here because I'm not doing that kind of shit. Okay. It's just not happening. So that's where we are. I don't want facts. I want hot takes. Good point. His woman has an excuse. They're very busy. Yeah. JC always hitting the excellent points here. Okay. So that's all we're doing here for today, people. Whew. I got some stuff coming up on Leo Frank next Friday. And we still got Nick shit coming in here. I'm sweating. Wow, that's hot. What are we gonna use for the outro? Hang on. I wanted to play a different video. Let's see. Oh, I have it. Okay, we are going out. We're gonna go out with a little Australian love, praising this guy for what he stood for. He did.